So let's talk about powers of attorney. So your will says you're gone, you're giving your things away. Your power of attorney says, I'm not gone, but I'm not well. In the event of an incapacity. This newspaper article here came out in 1996. 1996 was a very significant year for law reforms across the board, and particularly with wills and estates. Before 1996, we had one power of attorney, dealt with healthcare and assets all in one. Was not particularly effective, but that is not why the legislature changed it. The legislature finally was prompted to change it because if there was theft or fraud, there was literally nothing we could do about it. What the legislature did was they enacted the Healthcare Consent Act so they could segregate asset management from healthcare management. So the power of attorney for asset management is very, like the default that we have now is very clear. It says, no one will sign anything for me. No one will do anything for me unless I really cannot. So, the power of attorney is no longer a standalone document. It has to have a medical assessment. So if your spouse even goes to the bank and says, I'd like to pull $50,000 out from my wife's account, I've got a power of attorney, the bank person will say, well, where's the letter of assessment? The old style general power of attorney still exists. We can use it, but we use it very sparingly. So if somebody says, oh, I want my spouse travels a lot and I want to make sure that I can deal with stuff, that's fine. We'll make it limited in scope or limited in time or both, right? Because it's effective right away. We won't put a substitute in there because we want to reduce the risk. We will limit the time. So when's your spouse coming back from this business trip contract? Oh, in 6 months. Okay, so it expires in 6 months. So medical decisions are a power of attorney for care. That's the second kind. So we are assuming now these days that when people, we're doing it as a package, like people are doing wills and powers of attorney. To me, it's more important to have the power of attorney even than to have the will, because the statutes on the wills are very set. Wills have been around for a really long time. We have a lot of case law. We've got Succession Law Reform Act that tells us who the next of kin is. We know how much is going where. Like, things are pretty settled, whereas powers of attorney are still in their infancy. And the issue is let's say you have a house with your spouse and one of you is incapacitated, the other one can't do anything, can't list the house for sale, can't register any kind of loan against it to care for you. So even with first-time buyers, we're telling them you should get a power of attorney. The point of this article is, if you feel strongly you would not want to be in a vegetative state, you should indicate that in what's called a letter of wishes. A letter of wishes gets attached as a schedule to your power of attorney, and it indicates whether or not you'd want to be in a vegetative state. It says, I'm not as afraid of dying as I am of losing my dignity. If there's really no hope for my recovery, please let me go naturally. Give me the medication to keep me comfortable, even if it should hasten my death. I just don't want to suffer in my last days unnecessarily. Wills are tricky. I mean, it's misleading. The price point is misleading. The ease, like what you see, not knowing the ins and outs and what's going on behind the scenes is misleading. They're actually somewhat complicated. Yeah, so the recommendation is it's too important, just get it done properly.